Mr. McGinty.
Good morning, Your Honors.
Good morning.
May it please the Court. Attorney Sean McGinty, I represent Mr. Lucero. I was his trial counsel as well as his counsel at this point. This is a case involving a indecent assault and battery. The case was scheduled for trial on March 12th of 07.
And the witness and her guardian go to the wrong place, and Judge Murphy dismisses it. Or no, strike that. Enters a finding of not guilty.
That's correct.
Where does he get the authority to do that?
That was done in Commonwealth versus Super before this court, year 2000. It's cited in my brief.
And
that was a
upheld by
case.
us?
Yes. That
Even
was a case actually.
Even though the complainant was in another, was in the courthouse but in the wrong place?
Witnesses weren't there at all, period,
Yeah.
in that particular case.
In that case, they weren't there at all.
That's correct.
Yeah. And no evidence was taken in this case, correct?
That's correct. That's the same as in the Super case. There
So
was no
you would
witnesses.
agree there's no double jeopardy here?
I would say there was no double jeopardy here.
Okay.
Well, but by definition, if you accept a finding of not guilty, then jeopardy has certainly attached, because that's the disposition of the case.
I stand corrected. I would say I do. That is my position. I would say jeopardy does attach. The witness clearly was told to come to room 220 of the district attorney's office and sits in another courtroom. Clearly, as my brief outline, is a very reluctant witness. My client's daughter, who's now almost 17. It was the witnesses were there. My client waived the jury. Witnesses didn't show up. Judge directed a verdict, and the judge can do that. And it has happened in other cases where they count even on an opening statement. Judge can direct a verdict on an opening statement without any witnesses. So I'd say this is akin to that. This is akin to what the court allowed in the Super case.
What is the site of that? I'm sorry.
That's in my brief.
I just don't have it here. Sorry.
I'm sorry.
No, it's me.
That is it's a 2000 case. It's
431.
431,
492.
492, or 493.
Thank you.
That's correct. That case, the Commonwealth didn't have their witnesses. It was sort of a short notice case. In that case, matter of fact, the Commonwealth moved for a continuance, and it was denied. In this case, Commonwealth didn't move for a continuance.
But the trial had already started in that case, didn't it?
No. No, it did not start in that case. Prior to the trial, the Commonwealth moved for continuance. The judge denied it. In this case, the Commonwealth never moved for continuance until 3 hours after the judge already made his ruling. And matter of fact, in this case, the Commonwealth filed a 211-3 petition the same day of the court's ruling. In this case, the Commonwealth waited 44 days until after this occurred. I suggest at this point, Judge, I'm asking that my client be allowed to get on with his life. This is a case where very weak evidence. The complaining witness made 3 separate recantations to different people.
We really can't get into that.
Well, isn't that up for the jury to decide?
Yes, it is for the jury to decide. But what I'm saying is this isn't just a case where the court should overturn what the judge did. It's a case with very little evidentiary value. Along with the Commonwealth, the witnesses' very reluctance to testify.
Thank you, Mr. McGinty.
Thank you.
Good morning. May it
Ms.
please the
Sullivan?
court. Jane Sullivan for the Commonwealth. Judge Murphy had no authority to do what he did in these circumstances. Jeopardy had not attached. There was no trial on the merits. No judge has the authority to enter a not guilty verdict before trial has begun or jeopardy attached.
What do you say about the Super case?
Super jeopardy had attached because the judge, even though it was over the Commonwealth's objection, and the Commonwealth had asked for continuance and was denied, the judge started impaneling the case. And the prosecutor, in that case, just simply said, well, I'm not moving for trial. I'm essentially not participating. And this court said, no, you can't just pick up your football and go home. You have to stay in the game.
Remember the case,
And you can get the stay. You can ask for a stay, but what you can't do is what you did. And in this case, the defendant did say that he wanted to go jury waived. There was a colloquy about that. There was inquiry about the witnesses. The prosecutor represented that she had spoken with the victim and witnesses over the weekend.
Actually had issued a subpoena, as I understand.
Had actually issued the subpoenas, and there's an affidavit from the victim and the witnesses that they were actually in the courthouse at 8:30 in the
But
morning.
How is that relevant? Whether they were there, they'd gone to the wrong
Right.
courthouse, that has nothing to do with the judge's, whether jeopardy is attached and whether the judge appropriately made the ruling.
Right, that's absolutely true, Your Honor. And the fact of the matter is, right, the double jeopardy issue is key here. This wasn't even a sham trial, as it was in Gonzalez, cited in my brief, or in Louder, where trial had started and the prosecutor had given his opening argument. Jeopardy simply had not attached. The judge should not have done what he did. At worst, he could have dismissed the case without prejudice. I would be arguing that even that would be extreme in the circumstances here that came to be known, but he certainly could not have entered a required finding of not guilty. And so for those reasons, I would ask this court to affirm the order of the single justice and remand the matter back to the Superior Court for trial.
Thank you, Ms. Sullivan.
Thank you.